As the protected person in this order, I'm requesting to have the no contact order rescinded in regards to Joseph Wellman. There has never been a history of domestic violence in our household, and this allegation has created an unnecessary and extremely stressful situation. We have built a stable and healthy life over the past 12 years, and including raising his son together, which I mentioned in that in the motion. I'm not currently and have never been in fear of my well-being or safety with Joseph Wellman, and I respectfully request that the no contact order be rescinded so that this prevents further harm to our family.
I have here a request to remove the no contact order that was entered earlier. And so I've read your written statement regarding that. Is there anything else you'd like to tell me before I decide?
Sorry, Your Honor, you said you read my written statement. Are you talking about the motion to rescind / modify?
Yes.
Okay. So, Your Honor, as the protected person in this order, I'm requesting to have the no contact order rescinded in regards to Joseph Wellman. There has never been a history of domestic violence in our household, and this allegation has created an unnecessary and extremely stressful situation. We have built a stable and healthy life over the past 12 years, and including raising his son together, which I mentioned in that in the motion. I'm not currently and have never been in fear of my well-being or safety with Joseph Wellman, and I respectfully request that the no contact order be rescinded so that this prevents further harm to our family. I did on the bottoms put motion to modify if the motion to rescind is not accepted. I don't know how that process works, but I figured I should probably add that on there.
No, it works exactly like this. We can address all of that right now. Oh wait, just going to ask you a couple of questions.
Yes, Your Honor.
How old is your stepson?
He's 10 at the moment.
10. Okay, and besides you and your stepson and Mr. Wellman, who else resides there?
Nobody, just the three of us.
Okay.
Yeah.
All right then, and Mr. Coleman, I know you join in this request. Is there anything else you'd like to add?
Just that, Your Honor, I understand kind of the immediate nature, especially in our state, when we put these 1099 pretrials on. But in speaking with both of these individuals separately, I can honestly, in all candor, say to the court, is there does not appear any evidence at all of a systematic power and control of domestic violence or the typical domestic violence, characteristics that would necessitate an order like this. It's causing a significant amount of hardship. These people are educated, they are savvy. I don't want to litigate this issue now as is inappropriate, but at this time, under 3.2 and the general nature of these 1099 pretrial orders, it seems more appropriate to simply just recall the order at this time, order these individuals not to communicate about the case, order them to have no assaultive or harassing behavior order my client towards, and that would satisfy 3.2. And with the lack of there being any power and control or systematic domestic violence, alleviate the undue hardships caused by this order, and really keep more in line with pretrial orders and the release conditions. Again, we're not trying to litigate right now. That's just our pitch with this order.
Sure. Thank you, Mr. Coleman. All right, Ms. Hewitson, does the state have a position with regard to this request?
We do, Your Honor. Your Honor, when Mr. Wellman was last before the court on his preliminary appearance back in January 20th, the court allowed for a modification for electronic communications for child care and finances. And I can tell the court that years ago, I would not have agreed to any modifications, but I recognize that people have lives that they need to coordinate, and they need to have controlled communications so that they can pay bills, so that they can manage child care. And so I think that's the appropriate modification so early in the case. As I'm sure counsel will agree, none of us present today are treatment providers who have sat down with Mr. Wellman for a significant amount of time, sat down with him, reviewed police reports, and made a knowing, intelligent assessment of what needs to occur before these two parties are together. This was an assault that was witnessed by a third party. This is not a he said, she said situation. Alcohol was involved. State would like to see an evaluation by a treatment provider, recognizing everything that went on, reviewing every document that's available, that can make an educated recommendation to the court. At this point, the state would object to a modification of the order beyond what is entered currently. I think it allows for those immediate contact needs that needs to happen so that those basic human needs of finances and childcare can be met. And given Ms. I understand has her own views, but she is still a material witness in this case. And in any other type of criminal action, we would be asking the court for no contact between the defendant and material witness. So the state believes that the modifications in the order are appropriate, and we'd ask for no future modifications at this time.
Thank you, Ms. Hewitson. All right. And as we've gone along here, I've also reviewed the documents from the preliminary hearing and more refresh my recollection about them because I did enter those orders. And I think I did advise that she could always ask the court to further review the order to make any changes that might be appropriate in the future, up to and including removing the order. So as I want you to know that the court does hear you, and even though this is a case technically between the state of Washington and Mr. Wellman, that your participation in this or your status in this case is not ignored just because you're not a party to the case. You do have the right under our state laws to come to court and ask for the order to be removed because it affects you, even though you're not subject to the order itself. So, with that in mind and with the circumstances of this case, this court having been advised on 2 occasions now of the circumstances of the case and your wishes with regard to this order, I don't believe at this point that it's appropriate to make any further changes to the order. My belief at the time, and it's still my belief, that the exceptions placed in the order were adequate to address the immediate needs of your household without putting undue pressure on you, recognizing that there nevertheless will be pressures and inconveniences. That is the nature of a no contact order. That does not enter into a family circumstance without causing hardships. I'm fully aware of that. I'm not disregarding the fact that this is difficult for you. But on balance, the interest that I have to weigh in making this decision, it still today makes sense to me as it did when the order was entered on January 20th. So I won't change the order any further today. However, just like January 20th, the door is still open for further review based on circumstances that may change and need to be presented to the court. All right, so Mr. Wellman and Mr. Coleman, we're going to set this case for further hearings, and I want to verify contact information for you, Mr. Wellman, so that we can get notice to you. We have P.O. Box in Lacey. Is that a good mailing address?
No, sir.
Do you have a better address for me?
If possible, could you just go through my attorney and I can get the information from him?
I can do that if that's your wishes, yes. We can contact you through Mr. Coleman's office, and the other thing we do is text notices to remind you of court dates. Did you get one for today?
No, sir.
Do you want to get those?
Please.
Okay, can you give me a phone number that I can put in the record for texting?
It would be 360.
Okay. All right, we'll get notice out as soon as the court date's set, and we'll see you back here then. All right.
Thank you, Your Honor.
Anything else, Mr. Coleman?
So will the clerk later notify us of court dates?
Yes, that's correct.
Thank you very much, Your Honor. I have nothing further. I appreciate